Dear learners, we shall be beginning with the part 2 lecture on the kinds of business organizations. The title of the lecture is Introduction to a Company. Now, in the previous part 1 lecture, we have taken a bird's eye view or a primer of the various kinds of business organizations. So, starting from this lecture, we shall be undertaking a detailed examination of each of these business organizations. Now, beginning with a company. Now, because a company is one of the most popular yet most complex kind of a business organization, so we shall be taking up a company in a series of different lectures. So in this part 1 lecture, we shall be introducing you to what is a company and what is its legal framework. So to define a company, it is very difficult to define as there are at least 28 different kinds of companies which we will discuss later under the topic kinds of companies. The 28 kinds of companies, as I mentioned, they have variable features and structures. So in the definition part, we will try to identify if there are any common features or expressions which can be used commonly for all kinds of companies taken together. Now, under the law, the Companies Act, we have a provision that is Section 2, Subclause 20, which makes an attempt to define a company. So, according to this provision, company means a company incorporated under this Act or under any previous company law. So, as you would acknowledge that this is a very technically worded definition which does not reveal much about the meaning and features of a company. So to look at it in a non-technical jargon, the word company is derived from two different expressions or Latin words. First is com, meaning in English together, and panis, meaning bread. So this expression reflects the historical association of business with people gathering for a common purpose, often symbolized by sharing a meal or bread. So it was like an informal gathering of people who were engaged in businesses who met over dinner, lunch, or other kinds of meals. So it denotes a practice which is rooted in history when merchants or businessmen gathered during festivals during which they discussed business matters. So in common parlance, or generally speaking, a company denotes an association of like-minded persons formed for the purpose of carrying on some business or undertaking. A very popular definition of a company is by a known jurist who goes by the name of Justice James. In his word, a company is an association of persons which are united or brought together or conjugated by a common object. So some of the key expressions that you see here is association, meaning thereby there are multiple persons who come together for a common purpose, and that common purpose is symbolized by an institution that is known as a company. Now there is another very detailed and definition of company by another known jurist, Lord Justice Lindley. Now he has defined a company in the following words, as you can read on the screen. So for your benefit, I have highlighted some of the expressions in red so that you could know what are the important keywords in this definition. So he defines a company as an association of many persons who contribute money or money's worth to a common stock. And this common stock is employed in some trade or business. Subsequently, they share the profits and losses arising therefrom. The common stock so contributed is denoted in money and is the capital of the company. The persons who contribute in it form or to whom it belongs, they are known as members of the company. The proportion of capital stock to which each member has contributed is his share in a company. So as we know that the members of a company, they are known as its shareholders. These shares are a kind of a movable property which are transferable from one person to another person. So what Lord Justice Lendley has done is that he has tried to simplify by giving us certain keywords of a very complex organization that is known as a company. Now moving on to what are the various different laws that regulate the functioning of a company. Now this is a very common knowledge that the functioning of a company is governed only by the Companies Act. While this is true to a large extent, but there are certain other laws also which go on to form and shape the legal framework governing the companies. So beginning with we have constitutional law. So under the constitution, 7th schedule, there is list 1 which is known as the union list, in which there is entry 43. So just to give you a brief highlight of why are we referring to the constitution, especially for those who are not from law background, is the source of all laws which are made in the territory of India, whether by any state legislature or by the Parliament of India. The source of all laws has to be in the constitution. So company law being a domestic legislation, it also has to have a source in the constitution. So entry 43 of the union list, which talks about legal regulation of business organizations, so the company law is sourced from it. Then next is a kind of a law that is known as a legislative law. So in exercise of entry 43 under the union list, the Parliament has enacted a legislative law which is known as the Companies Act 2013. Now this Companies Act 2013 is the most important and the influential law which governs the functioning of companies. After that, we have a delegated legislation which are in the form of company rules. Now, for the functioning and regulation of companies, there are some matters which are given under the Act. But there are certain other important matters which are not given under the Act, but certain rules are framed. Now, these rules, they are framed by the bureaucracy. So, the Parliament has enacted the Companies Act 2013, and then we have company rules which are enacted by the Ministry of Corporate Affairs. So the rules are essentially supporting laws for the Companies Act 2013. So while making any changes, modification or amendment to the legislative law requires parliamentary approval, the delegated legislation in the form of company rules, they are much more flexible and easier to amend because they are done by the Ministry of Corporate Affairs. Now after that we have a company constitution which goes by the name of Memorandum of Association and Articles of Association, the short form of which is MOA and AOA, Memorandum of Association and Articles of Association. Now these Memorandum and Articles of Association, they are the kind of internal documents of a company as to how a company should function. So it is like all the members who have come together to form the company, they come to an agreement. Now that agreement is reflected in the provisions of the memorandum and the articles. Then after that we have company contracts. because company as a business organization, it enters into contract with outsiders or other people in order to carry on its business activities. So there are contractual dimensions which also influence the functioning of companies. Then we have decisions of shareholders or members of a company which are reflected in the general meetings of the company. So the shareholders, they meet from time to time and they pass certain resolutions about the business of the company. That resolutions, they are known as resolutions of the members, which are taken in the general meetings of the company. Then there are certain decisions of the management, which consists of the board of directors, who are the managers of the business, along with other key managerial personnel like CEOs, CFOs, COOs, so on and so forth. So the resolutions which these managers take in their meetings, they also form a part of company law. So this is to give you a very exhaustive and a detailed hierarchy of laws that affect the functioning of the companies. Now, the laws that we have discussed in the previous slide, they could be classified under two broad heads. One is known as external and the other is known as internal. Now, we call external laws those which are made by any organization outside of the company. So, for example, we have the Companies Act 2013, which is made by the Parliament of India. So, we call it as external. On the other hand, internal laws are those laws which are made by the company itself and for itself. So, for example, we have the Memorandum of Association, the Articles of Association. They are internal laws because they are made by the company itself. So, there are certain laws which come from above, like the Companies Act, company rules. And there are certain laws which come from within, which are known as internal laws. Now, the external sources, like the constitutional dimensions, entry 43 of the Union List, which we discussed a short while back. We have the Companies Act 2013, the company rules, as well as case laws. By case laws, here we mean any judgment of any court which lays down a mandate on any particular dispute that has arisen between two companies or within a company amongst its various stakeholders. So, if any judgment comes, now because a judgment is by a court of law, which is not a part of company, so therefore we label case laws or judgments of courts as external sources. So, in the hierarchy that we have just discussed, we have identified these four external sources. Then internal sources are Memorandum of Association, which is known as a kind of a company constitution, along with the Articles of Association. It is like an internal rule book for a company. So just like we have the police, which has a police manual, in the same way there is a company manual as to how a company should function. It's internal documents. Then we have company contracts, which the company will enter into outsiders for the purpose of carrying on business. Then we have resolution of the shareholders in general meetings and the resolution of the board of directors. So these are the internal sources. Now, just to summarize you, so the various laws that regulate the functioning of a company, they could be classified under two heads, external or internal. On the left hand side of the screen, I have enlisted here the external laws, and on the right hand side we have the internal laws. Now moving on, there is another important point which I wish to discuss, is that because a company deals with a multiplicity of laws. There are many external laws, there are many internal laws. And so when any business organization deals with multiplicity of laws. So law is like an authority which the business organization is subject to, just like we as subjects, human subjects, whether we are students in a university or employees, we are also subject to some authority above us. If there are multiple authorities, then sometimes there is bound to be a conflict of directions which are issued by different authorities. So we have section 6 of the Companies Act which lays down a rule as to what is going to prevail or going to have an overriding effect in case there are multiplicity of laws and there are conflict between those laws. So we have part A of section 6 which reads as follows. Some of the keywords I have underlined for your benefit. So section 6 part A clearly lays down that the provisions of this act, by this act we mean the Companies Act, it shall have effect notwithstanding anything to the contrary contained in the memorandum or articles or any agreement which is executed by the company or any resolution passed by the company in general meeting or by its board of directors. So what it essentially says is that if you have any provision of the Companies Act on one hand, which lays down any rule, and on the other hand, we have any contradictory rule which is laid down either in the memorandum or the articles or any contract that the company has made with an outsider or any resolution which the company has passed in its meetings, it is the provision of the act which is going to prevail. Now, in part B of section 6, it further makes the point clear by laying down that any provision contained in the memorandum, articles, agreement or resolution, to the extent to which it is repugnant, or meaning thereby in conflict to the provisions of the act, it shall be void as the case may be. By void means it shall have no legal force. So section 6 essentially lays down that the external sources of company law are considered to be more important or sacrosanct as compared to internal sources. So for example, here we have the external source of an act and we have the internal source of memorandum and articles. So in case of conflict between external sources on one hand and internal sources on the other hand, it is the external sources that are going to prevail. Now we will be briefly giving you a glance and a glimpse of certain core characteristics of a company. Now, a principal function of a company law is to provide the business enterprises with a legal form that possess these 6 core attributes, which are number 1, legal personality, number 2, limited liability, number 3, delegated management, number 4, ease of raising finances, number 5, transferability of shares, and number 6, perpetual succession. Now, by making this form, which has these 6 core characteristics very widely available through company legislations around the world, these are very investor friendly and user friendly. They enable the company law to become a very popular choice for upcoming entrepreneurs to interact easily through the medium of a company. And it also significantly lowers the cost of conducting the business. So in the upcoming lectures immediately after this one, we shall be taking up each of these core characteristics of a company, which will also help us in understanding some of the other business organizations that we shall be taking up later. So the concept of legal personality, limited liability, how the management has to be done, how the finances have to be raised, whether the investor can transfer their investment. So these are some of the issues that are common to all business organizations. So for the ease of your understanding, we shall be looking at them in detail when we discuss these individually. So just to summarize the discussion of this lecture, we have undertaken a discussion on the definition of a company, where we looked at the definition under the Companies Act, as also some popular legal definitions. Then we had taken up the various kinds of laws that affect the working of a company. These laws could be categorized either as internal or external. And then lastly, we have taken a cursory reading of the 6 core characteristics of a company, which we shall be discussing in detail in the next upcoming lecture. With this, we conclude the part 2 lecture on the kinds of business organizations, which is Introduction to a Company. Thank you.